Good morning, everybody. Hopefully you can all hear me. If not, then if you could just maybe pop something in the questions tab, which you will be able to see on the left-hand side of your screen. Just let us know if you can't hear us. But for those of you who are here, my apologies for my background. I'm obviously working from home during lockdown. Thank you very much for attending our session today, which is on the new immigration system. As you all know, despite the fact that we are living in unprecedented times, the government is still pushing ahead with Brexit, which means that from 11 p.m. on the 31st of December 2020, we'll have a new system. And that will apply to all EU citizens who are not in the country before that date. I'm joined today by my colleagues Alex Christen, an associate, and Alice Williams, a solicitor. We are all employment and immigration lawyers here at Capital Law, which means that we can advise you on both employment and immigration aspects around working visas, which are often interlinked. So I'll quickly go through the agenda for today. We'll start off by taking you through an overview of the new system, what businesses will need to do to recruit from outside the UK from the 1st of January 2021. We'll then discuss how this will impact businesses and the pros and cons of this new system. We'll then take you through the other routes available and the changes which have been made, if any. There are some routes where very minimal changes have been made. And then we'll take you through right to work checks and tips on what you can do to prepare for the new system coming in next year. This will be followed by questions. So if you could put your questions in the questions box on the left-hand side, and we'll try and get through as many as possible of these at the end of the session. If we don't get to your question, feel free to email us separately following the session. Just to also let you know, we'll be working in partnership with Satinder Gill, who's a renowned business immigration barrister at 5 Paper Barristers in London. And we'll be producing a series of podcasts, which are around 15 minutes long each, on frequently asked questions on the new system. So please watch out for these, which will be coming out later in the month. You'll be sent links to these podcasts and the recordings, and they'll be available on our website, along with a recording of this webinar. So I'm firstly going to take you through an overview of the new system. So I put on the slide there the kind of history of where we are now. So on the 19th of February 2020, the government announced the details of the new post-Brexit UK immigration system, with significant changes to the rules governing entry to the UK due to come into effect from next year. Further details were then announced in July, which added to the February 2020 policy statement. And although there were a raft of additional technical details and relevant appendices, there was very few new policy announcements in this paper. Other than ending free movement of EEA and Swiss citizens, the major change within the current proposals relates to the criteria for entry to the UK of skilled workers. And we will go through that in more detail during the webinar. Whilst many of the routes will remain similar, if not the same, to those that currently exist, what the government have said is they want to commit to a simplified and consolidated version of the current immigration rules. So the transition period will end on at 11 p.m. on the 31st of December 2020, and the new immigration system will take effect after that. It's possible to make applications under the new rules from 9 a.m. on the 1st of December 2020 in most cases. We haven't received any guidance on that of yet, but we are expecting that to be published in the near future. Free movement for EU, EEA and Swiss citizens will end, and EEA nationals will not be able to apply in-country under the rules until after 11 p.m. on 31st of December 2020. But that's unless they're applying under the EU settlement scheme or as a healthcare visitor or a service provider from Switzerland. Those who do apply for entry clearance will be granted clearance from the 1st of January 2021 at the earliest. What the government is saying is that they are aiming to introduce a fairer, simpler immigration system. And for those of you who have dealt with the immigration system under the existing rules, you'll know that it's quite complicated. It can be overly administratively burdensome, and so the government has promised to try and simplify the system, to try and move towards bringing in those individuals from outside the UK who can bring skills and contribute to the economy. We've put up a slide there about becoming a sponsor. The reason we put that up there is because those of you who haven't or don't recruit from outside the EEA at the moment, you might not be aware that in order to sponsor people, you need to be a sponsor license holder. This will mean that from 11 p.m. on the 31st of December this year, you will have to become a licensed sponsor if you want to bring skilled workers from outside the UK to work. The government has said it will be publishing new guidance on how to apply if it's something that you want to do. And those of you with existing licenses, the government will automatically transfer over your existing license, and you should receive correspondence from the government or the Home Office on that soon. I've briefly outlined on the slide what needs to happen to become a sponsor. So first of all, the company needs to apply online. That involves filling an online form and just providing information on the company, what sector it works in, office address details, how many people work for the company, that kind of thing. You also have to pay a fee, and the fee depends on whether you're a small company or a medium to large company. And then you have to provide documentation to show that the company is genuine. So this will involve providing certificates of insurance, details of audited accounts, some of the usual documents that you upload to Companies House. This is usually the most burdensome aspect of it, because if you are sending documents, they need to be certified in a certain way. So I'll take you through what has changed from the existing system into the new system. So we've put on the slide there the changes that have been made, so that you can see that those are the ones that we've identified are probably the most important ones. Whilst there have been a raft of other small administrative changes, these are the ones that we think are most important. And I'll go through those as well in some further detail. So the new points-based system is now a tradable points-based system. Although the existing system was called a points-based system, it's not really a points-based system in the traditional sense. Other immigration systems around the world are called points-based systems because they have a system of tradable points, which means that an applicant, if they're given points in each category, they can offset certain points in desirable categories against others in order to achieve a minimum number of points and be eligible to apply for a visa. In the UK, there were points awarded for each category, but you had to get the maximum number of points in each category, otherwise you wouldn't be eligible for a visa. So it was an all or nothing approach, really, rather than a traditional points-based system as we would know it, looking at other systems across the world. You will have heard that the government were very keen to base their system on the Australian system, and that's a tradable points-based system. What will happen now is that there will be tradable points available to allow applicants who might not necessarily meet the minimum number of points required to trade off certain points to achieve the minimum that are required. And we'll talk about that later in the webinar. The general threshold, the general salary threshold has been reduced. This has been one of the bigger things in the news that you've probably all heard about, that the salary threshold was reduced from 30,000 to 25,600. That's the minimum salary threshold, or it's the minimum required for the job. And I'll go into that in some further detail later in the webinar. The skill threshold has also been reduced from RQF level 6 to RQF level 3. What RQF means is it just means the experience or qualified level of a job. So RQF level 6 is degree level. So if you have a job that is qualified to degree level, it either means the individual has to have a degree equivalent, or that the job is skilled to that level. We know that there are lots of jobs out there where individuals don't have degrees, but they're skilled to that level, having done the job for a number of years and they've got that experience. RQF level 3 is the equivalent of A level. So you can see it's come down quite substantially from degree to A level, which means that it's able to encompass a wider range of jobs that were previously excluded from the existing system. The resident labour market test has been abolished. Though for those of you who have sponsor licences, have recruited from outside the EU under the existing system, you'll know how laborious the resident labour market test was. I'll briefly explain that later on in the webinar. But what it required was a business, if they wanted to employ someone from outside the EU, they'd have to advertise the job first in the UK to make sure there was no settled worker in the UK who could do the job before it could be offered to somebody outside of the UK. The cap on certificates of sponsorship has been suspended. And the reason that we've pick this as being an important thing is that those of you who recruit under the existing system, you'll know that for certain kinds of jobs you need to apply for a certificate, and there's a cap on the number of certificates that can be given out in that month. There was a situation a couple of years ago, around about, I think, the end of 2018, where the cap was being exceeded significantly for months at a time, which meant that those who had valid applications and were earning quite substantial amounts of money were not getting through the process. And if it's not accepted in that month's process, it rolls over to the next month. This meant that for the NHS, where doctor and nurse roles were within that category where you had to apply for those certificates, were finding their applications were being rejected and they were being delayed, and the NHS was finding that they were finding the skills that they need weren't being, those skills gaps weren't being filled. As a result, the government have said that they will suspend the cap for the time being. That's not to say that it is gone completely. It is possible the government might decide to implement it again, but they have suspended it for now, which is a good thing to bear in mind. There are changes to the intra-company transfer route. And for those of you who recruit under the existing system, you will know that this is a visa which allows you to bring over workers who work for an affiliate company abroad and who have worked for that company for 12 months or more. Or if their salary is over a certain level, they don't have to work for that 12 months. And you can bring them over to work in the UK affiliated company. Alice will be talking about that in some further detail, so I won't go into that here. Changes to cooling off periods. So this is an interesting one, because those of you who do recruit under the existing system will know that the Tier 2 General Visa, which is the skilled worker visa, as of next year, that an applicant can only be on this visa for 6 months, a maximum of 6 years. So the initial application can be for no longer than 5 years, at which point they are entitled to apply for indefinite leave to remain if they meet the minimum salary threshold. If not, they can extend the visa again for a further year. They're then not permitted to extend it further, have to leave the UK, and cannot apply for a visa like this for another 12 months. That cooling off period has been abolished. So theoretically, someone could continue to apply for 5-year visas with a year on extension indefinitely. There are limited situations in which you would do that. For example, if you don't meet the minimum threshold for indefinite leave to remain. But it's interesting that the cooling off period has been abolished so that somebody could come to the UK on a skilled worker visa indefinitely. Again, there's no 6-year cap on total lengths of stay, which means that, again, skilled workers can come to the UK and don't need to leave after a certain period of time. Another important aspect is that in-country switching has been expanded to a lot more categories. So usually, for example, if someone was on a spousal visa or an intra-company transfer visa, any of the skilled worker visas, it was very difficult to switch to another visa in country. That applicant would have to leave the country and then apply within their home country or another country and then re-enter the UK on the new visa. This obviously caused lots of issues and unnecessary stress for those applicants, because if their application was denied, then it's possible they had no ability to access or come back to the UK, where they potentially left family and children. Again, the Home Office says that the new system will be simplified, and we're waiting for further information on that in terms of how to apply for a licence. And the Home Office have also introduced a new £500 fee from the 12th of November 2020 for priority processing. So it takes about 8 weeks for a application for a sponsor licence to be decided. The government have now introduced a fee for which you can get your application fast-tracked if you needed to. So the scoring of points, this is the tradable point system. This will replace the skilled worker visa, for which you would need these tradable points, will replace the Tier 2 general visa. So as I've said on the slide, the applicant needs to achieve 70 points before they can apply for a skilled worker visa. The first 50 points are awarded for the first 3 elements on the slide, which is that they need to have a job offer from an approved employer sponsor, meet the required skill level under the new system, which must be to RQF level 3, so equivalent to A level, and also speak sufficient English. The next 20 points are earned if the worker meets the minimum general salary threshold of 25,600 or the going rate for the job, whichever is higher. However, if a skilled employee earns less than that, but no less than £20,480, they'll be able to trade points, providing that the job that they're doing has specific characteristics. So those include being on the shortage occupation list. And for those of you who don't know what that is, it's a list that's produced by the government, which just lists all of the roles for which there is a skills shortage in the UK. So the government want to bring people in order to fill those positions because they help the economy. Historically, the kinds of roles on that list would be technology, construction, engineering, that kind of thing. And technology has featured quite consistently in the last few years. The applicant has a PhD in a listed occupation, which is relevant to the job, and there'll be additional credit if the PhD is in the STEM sector. Is applying to work in a listed health and education role, for which then the salary will be relevant to the national pay scale. Or the individual is a new entrant, so they are under 26 at the date of the application, working towards a professional qualification, and they're switching into the category from a new graduate route. Providing the applicant achieves 70 points across the criteria, then they'll be permitted to apply for a visa. It's really important to be aware that it doesn't mean that the visa will be guaranteed success, because it still needs to be reviewed by a caseworker, but it means that the eligibility to apply is there, and unless there is anything seriously wrong with the application, then it should in theory be successful. So just looking at the general salary in some further detail, ignoring the tradable points, the minimum is 25,600 or the going rate for the occupation. So this is where the SOC codes come in. And for those of you who don't know what that is, SOC codes are a list of all of the jobs that you can think of. And against each job are example job titles and example job responsibilities. And then against that is the going rate for the job. So if the going rate in the code for which you identify is most suitable for the job you're wanting to recruit for is higher than the general salary, that's what you must pay. You cannot pay lower than that. You'll see that we put on the slide that in terms of the general salary, the going rate for the new entrant will always be 30% lower, and that's going to continue. There was talk about there being regional salaries, minimum salaries, of course, because of London waiting, but that has been discounted as a possible option by the government. So the required skill level in some further detail. Obviously, with the reduction in the skill level, it means that workers from outside the UK can come to the UK to take on a number of a significant number of extra roles that under the existing system would have not met the minimum skill level. And it, as I said, it's to RQF level 3, which is A level or equivalent. So that does open it up to a lot more roles than under the existing system, and can include some administrative roles that were previously didn't meet the skill level. The removal of the resident labour market test and the cap on certificates of sponsorship. As I said, the certificates of sponsorship cap has only been suspended. It's not been completely abolished, but it just means that you're more likely to be guaranteed that your application is going to be successful for a certificate, and that you won't have to worry about there being a cap, which, as I said, caused an issue a couple of years ago where applications that would normally get through were being postponed for a number of months because the cap was continuously exceeding. The resident labour market test, as I mentioned at the beginning of the webinar, this was a requirement to advertise a job in a special way for 28 days, see if there are any suitable settled workers available to fill the vacancy. And if there was a settled worker who was available to fill the vacancies, they met all the criteria, you would have to recruit them. You couldn't recruit the person you had your eye on, even if they were the better candidate. In reality, the resident labour market test wasn't really doing what it was supposed to do. In some cases, you'd have an employer who's struggling for weeks or months to fill a role. They then find someone from outside the EEA, and then they have to advertise it all over again. Or employers are so determined to recruit the person that they've identified that they will try and get the job description to fit. This wasn't allowed under the system, but it's very difficult for the Home Office to challenge it because it's the employer that knows the job requirements. So all in all, the resident labour market test was just adding to the administrative burden already in place under the system. So the government has said they will abolish it, which I think makes things a lot easier. So what has not changed? Now, the genuine vacancy test has always been something that has been within the rules, in that there has to be a genuine vacancy. But given that the resident labour market test has been abolished, we think that we're going to see the Home Office shining a spotlight on this when they're looking at either with the certificates looking to approve them or during audits. What I have seen when looking at the new rules is that the caseworker who will be looking at the application for a certificate, or the caseworker who is looking at auditing the company, what the basis for them having a look at the genuine vacancy test is reasonable grounds to believe that the job doesn't exist, or it's a sham, or it's been created for the applicant. So they can apply for entry clearance or permission to stay. So reasonable grounds to believe, you can see that's quite subjective. So although we don't have any information from the Home Office as to how this is going to be policed, we think that the Home Office are going to pay significant attention to it, which means that it's really important to ensure you get all your records in order. If that's something that you're worried about under the new system, please get in touch, because we're formulating a product that we will put together, which you can use to in order for you to demonstrate the genuine vacancy test, so that you know you're in a good position if it's ever raised by the Home Office. The immigration skills charge, for those of you who recruit under the existing system, you'll know this is something which is a real financial burden. This is a charge for you bringing in skilled people from outside the EEA or from the UK from next year. The fees are quite substantial and they have to be paid up front, which means that if you're sponsoring someone for quite a lengthy visa, so 4-year or 5-year, it can be quite expensive. So if you recruit 2 individuals on a 5-year visa each, that these fees are £1,000 a year, that's £10,000 before you've even got that person over. There are discounted rates for small businesses and charities, but in exceptional circumstances. And this is in addition to the migrant themselves having to pay the health surcharge, which is £624 a year. There's also going to be an emphasis on criminality checks, and the reason for this is that under EU law, the UK weren't permitted to bar some EU citizens from entry who had criminal records. So Priti Patel has been all over this and has been saying, we just don't want anyone who's got a criminal record coming in. So that means that criminality checks have been put up a notch. And it just means that anyone with a criminal record is going to find it very difficult to secure a visa. We put at the bottom of that slide to be aware of this during recruitment and carry out any due diligence that you need to, because the last thing you want to do is find that an individual you spent money recruiting has got a criminal record and they fail the criminality check. So I'm now going to hand over to my colleague Alex Kristen, who will take you through the tradable points system. Just bear with me while I transfer control to Alex.
Thank you, Angharad. Hopefully everybody can hear me. And morning, everybody, and welcome to our webinar. So I'm going to take you through the tradable points element of the new system in just a little bit more detail. So please bear with me. It initially can come across as quite confusing and difficult to understand, but once you get into it, it's actually quite straightforward. I will be repeating some of what Angharad has said, but we think it's important to really drill down into this part, because it's going to be a crucial part of the new sponsorship system. So as if I take you onto this next slide, we've put together a table which just identifies where applicants can gain points. And as Angharad has already explained, a sponsor, so a business with a licensed sponsor, a sponsor license, cannot employ someone unless they have a visa, and the individual will generally only be able to obtain a visa and apply for one successfully if they have the required 70 points. Some of these are mandatory. So the first 3 items on the list there, the individual must have an offer of a job by a licensed sponsor. This will get them 20 points. The job must be at the appropriate skill level, RQF level 3. That will also get them 20 points. And the individual must speak appropriate, have a sufficient English language skill, and that will get them 10 points. So that's the first 50. And after that, then the individual must gain a subsequent 20 points. And I will take you through some examples as to how they managed to do that in a few slides' time. So if I go back to, going on to sorry, 1 second, how it works in practice. And again, apologies if this does appear a bit repetitive, but it's really worthwhile getting into the nitty-gritty of this. As Angharad has already mentioned, for the salary, the starting position is that the applicant should be paid a salary of at least 25,600 per year, or the going rate for the role. And just to remember, you need to refer to the appendix in the new immigration rules to find the role that you're wishing to recruit into, and then identify what the minimum salary rate is, which the Home Office believes is the most appropriate rate for that role. And then you must meet either that minimum or 25,600, whichever is the higher. That will score 20 points, which is fairly straightforward. But you can pay a sponsored worker less than this in certain circumstances, and the less than wage can be as little as 20,480, or a percentage of the going rate, provided that the following criteria apply. So as Angharad has already mentioned, if the role is on the shortage occupation list, then that will get the applicant another 20 points. However, if I go back to my other slide, and we see here, if the job is on the shortage occupation list, that will get 20 points, and the salary can be anywhere between 20,480 or 23,039. So it can be at least 80%. It can be within that banding, or at least 80% of the going rate, provided that the job is also on the shortage occupation list. And there we have it, 20 points. Then we come on to a PhD. So if an applicant has a PhD, and it must be a PhD that's relevant to the role, it can't be a PhD in an entirely separate field, then a PhD on its own, which is not in a STEM subject, will only get the applicant 10 points. They then have to make up another 10 points for having a salary which is between the very low rate of 20,480 or the very high rate, or the bare minimum rate of 25,600. So if you look at the fifth line down, if the salary is in that threshold, or it is at least 90% of the going rate, whichever is the higher, then that will score them the required 10 points, which together with a PhD subject in relevant to the role will give them the required 20 points, making them up to 70. If they have a PhD which is also relevant to the role, but in a STEM subject, that will get them 20 points. And for that, then they only have to worry about the salary being at least 20,480 per year, or 80% of the going rate. Again, a job listed in a job in a listed health or education occupation will again get 20 points. And if the individual is a new entrant to the labour market, that will also get them 20 points. Just to make things even more complicated, if the applicant is a new entrant, then rather than their salary having to be at least 80% of the going rate, it can be at least 70% of the going rate, or 20,480, whichever is the higher. So I appreciate this is quite complicated. So I am now going to take you through a couple of worked examples just to explain what this all means in practice. The idea being, I think it came from a good place, that the Home Office wanted to allow more flexibility in the system. And as we are seeing in many situations with our government at the moment, that the way that it's being delivered can appear quite complicated. But if we take you through a couple of worked examples, then this hopefully should clarify what we mean by these percentage points. So the first example, Freya has been offered a job as a lab technician on a salary of 21,000. Let's assume for the purpose of this example that she meets the mandatory criteria. So the job is at the required skill level. She has sufficient English language skills, and she has a job offer from a licensed sponsor. So going to the appendix, the relevant appendix to the new immigration rules, the going rate which the Home Office have identified for lab technicians is actually 18,200. So this is less than the bare minimum salary of 20,480, which is, if that would be the higher of the two. So Freya's salary is 21,000, so it's more than the going rate, but because it's less than the general minimum salary that the Home Office have dictated across the board of 25,600, she scores no points, nil point for her salary. She has to therefore make up the 20 points elsewhere in order to make a valid application. She is able to trade those 20 points if we go back to the table, she's able to trade it in one of these items here. So in this instance, Freya luckily has a PhD in a STEM subject in biochemistry, which is obviously relevant to her role as a lab technician. She scores the 20 points there. We must also check that her salary is above the bare minimum of 20,480. It is only just, but it is. So she scores 20 points, giving her an overall score of 70, making her eligible to make an application. Taking the next example, we have Richard, who's been offered a job as a mechanical engineer on a fairly decent salary of 26,750. Let's again assume for the purposes of this example that he meets all of the mandatory criteria and gets his 50 points. So the salary then, we have to look at this. It is higher than the general across the board salary of 25,600. So on the face of it, you might think he scores the necessary 20 points. However, if you cross-refer the mechanical engineer role against the government's list of going rates for each type of job in the UK, then the actual going rate that the government has dictated for mechanical engineers is 33,400. So unfortunately, Richard's salary falls below that. And again, he scores nothing for salary. However, he is eligible to score 20 tradable points elsewhere because his salary of 26,750 is just above 80% of the going rate. So that takes him into the tradable points arena. In this instance, fortunately for Richard, mechanical engineers, as Angharad has mentioned, they are roles which are on the shortage occupation list, entitling him to another 20 points, giving him the required 70 points overall. So if I just give you one more example then, which takes into account this concept of a new entrant. So we have Evie, she's 26 years old and in the UK, having studied a veterinary science degree, and she's begun her career here under the graduate route. She wants to carry on working in the UK and wants to work as a vet on a starting salary of 22,900. Again, let's assume she's got the 50 points that she needs for the first three criteria. So she needs another 20 points. Her salary, it's 22,900, which is above the bare minimum salary of 20,480. We then have to consider: is it below 80% of the going rate for a vet salary? So the going rate for a vet salary is 32,500 per year. Now, ordinarily, ignoring the fact that Evie is a new entrant, if she wasn't a new entrant, then she would not gain the necessary 20 points because her salary would be below 80% of the minimum rate. But there is a concession for new entrants, which means that their salary can be 70% or more of the going rate, which hers is. She is 26 years old, so again, she is a new entrant, and therefore she is able to gain 20 points for her reduced salary, giving her a total of 70 points. So these examples will be in the handout section of these slides for you to go back to, again, if you want to go through them again, just to sort of cement your understanding of them. And again, as I've said, it can appear quite complicated at first glance, but once you go through them, it is actually quite straightforward to get your head around. So just quickly touching on, obviously the new system isn't even in yet, but looking further into the future, will this system keep on changing and evolving? And yes, it's very likely that it will do. The government has had to fast track this new system into place, given the speed at which they've had to examine a new immigration system as part of Brexit negotiations. And as Angharad has already mentioned, originally the plan was for an Australian style system, but instead what the government have tried to do is to shoehorn EU citizens into the existing points-based system. which is helpful in a sense in that a lot of the new system is very similar to the old system, and so it's easy for us to get our head around. But it is likely, as ever, that there will be changes going forward, and what we will have to do is wait and see essentially how the new system beds in, what the pattern of migration is like into the UK, and how the new system works in practice. But there are other quite significant variables at the moment, including the general economy and COVID-19. All of these are likely to have an impact on the net migration patterns, and therefore we might see a need for the system to be adjusted as it goes through the next couple of years. The government have hinted that the tradable points element of the new system might also be up for adjustments in due course, with tradable points later being added for things like age or previous study in the UK. Age potentially could be quite a controversial one, given that this has the potential to be discriminatory, but we will see, and we will of course keep you updated. So just after that whistle-stop tour of the new system, with all of this in mind, what does this actually mean in terms of your day-to-day ability to recruit people? So just want to take you through a couple more slides before I hand over to my colleague Alice. So how does this impact on recruitment? So the new system, the new sponsor system, is looking like it will be a lot easier compared to the old system. In particular, the removal of the resident labour market test means, as Angharad has said, that employers no longer have to prove laboriously that they couldn't fill the vacancy from the local labour market. Instead, they can skip to just simply recruiting the best person for the role, regardless of where they come from. Again, we have a shortage occupation list, which is in theory helpful, and if employers are ever struggling to recruit locally for a skilled role, they should definitely keep their eye on this list. If you're able to identify a vacancy on the list, which is a listed occupation, then it will reduce the cost of filling that role. This is, as I've mentioned, because you can have a lower than normal salary for roles on the list. However, we were expecting this list to be updated, and the Migration Advisory Committee, which is the advisory board to the government on all things immigration, who regularly produce reports for the government, which they by and large accept. In September this year, the committee recommended that the shortage occupation list be reviewed in light of the new system, in particular that there would be more healthcare roles added, and this is very obviously of great interest to the healthcare industry. It also recommended that there would be regional variations to the list. For example, Wales would have a slightly different list to England and Scotland. Unfortunately, just over a week ago, Priti Patel confirmed that they will not be endorsing the committee's recommendation, and they will not be reviewing the jobs on the shortage occupation list at this time. Instead, they want to let the new system bed in and to wait a while to see the impact of the coronavirus on net migration before they consider whether they need to amend the list. So that is a shame, but I would say keep an eye on it in due course. Hopefully it will be subject to review and more roles will be added to it. Another point to note that if you have EU workers currently in the UK should have by now, or should be in the process of applying for either settled or pre-settled status. And once they get those statuses, they are free to work in the UK in any role and at any skill level and at any salary, obviously providing it's above the national minimum wage. And there's no need to sponsor these people. They simply can work as UK citizens. So there's been around 4 million people apply under the scheme to date, which in theory means that there should be a sizable pool of EU workers in the UK that can be called upon to fill various vacancies which don't need to be sponsored. There are also other routes into the UK, aside from sponsorship and using EU workers who applied for settled or pre-settled status, and my colleague Alice will take you through this shortly. However, a big but, there is no route for skilled workers, and the government have been very clear that they are not going to adjust their plan on this. They have actually said that businesses will simply need to adapt and stop relying on cheap EU workforce, and this is a quote directly from the government. how realistic this is will very much depend on the business, the sector and the individuals involved. So there's many industries, as you can imagine, who will be impacted greatly by this new system. Care industry, as I've already mentioned, but also retail and hospitality, where at the moment there are large pools of EU workers working here in the UK in what the government deem to be low-skilled roles. These people will not be eligible for sponsorship under the new system, which will lead to huge skill gaps. We probably won't see the impact of this for some time in certain sectors, for example, retail and hospitality, given that restrictions have caused these businesses to either close down or stop recruiting, at least in the short term. So the impact of this might not be seen for some time. Then sponsoring. So in order to sponsor anybody under the new system, as Howard has mentioned, the employer needs to be a licensed sponsor. And this is, as Howard has said, there's a process that needs to be followed. There are fees that have to be paid. It's expensive and time consuming. And it does come with a lot of responsibility. Once you have a sponsored employee, the sponsor is under a duty to keep certain records for the duration of that person's employment, and also to basically keep tabs on them at all times, make sure they're doing what they should be doing, and report any activity to the Home Office. If these are all quite rigorous and time-consuming responsibilities for sponsors to comply with. If they don't, and if the Home Office ever came to do an audit on a company, on a sponsor, and they found that the sponsor was not complying with its duties, then as a worst case scenario, they could revoke the license, which could mean that the individual has a very limited time in which to either find a new sponsor or leave the UK. So it does come with quite a heavy burden. And also the process of becoming a sponsor is also quite burdensome and can take quite a long time. It's going to be a lot easier to recruit outside the sponsor license system than within it. Just really quickly, the government have said that the new immigration system will reduce the time it takes to bring a migrant into the UK by 8 weeks. We're not entirely sure where they get this 8-week figure from. 4 weeks of that is obviously taken up by the resident labour market test, so that has cut timeframes down quite significantly. But the process, there is still a process, and a process that has to be followed, and sponsoring an employee will always take longer than employing somebody not subject to immigration control, unfortunately. The government is trying to be a little bit more digital going forward, and EU citizens applying for sponsorship or even under the EU settlement scheme, their application will be done digitally. They won't need to go and enrol fingerprints, and they will be given an electronic visa rather than a hard copy of a biometric residence permit, which you may be familiar with. Non-EU citizens currently still have to have a biometric residence permit in hard copy form. But again, as I said, is it really more streamlined because you still have to be a licensed sponsor? If you're not already a sponsor, then you have to make the application. We would suggest that businesses do this as soon as possible. We have seen a real surge in businesses making applications, and there's inevitably going to be a huge backlog. The government insists that applications are only taking 8 to 10 weeks, but we have waited months for applications to go through for our clients in the past, and this was before COVID, so the system is in a bit of dire straits, and this is possibly why they have introduced the £500 fee for expediting applications, although it remains to be seen how quickly they will be expedited. And then finally, this new system is going to be up and running for the majority of the new routes by the 1st of December, so less than a month the system needs to be in place, and we still haven't had the detailed guidance that we've been promised. So we think the next few months will definitely be interesting. So without any further ado, I will pass over to my colleague Alice, who will take you through a few of the other sections now. Please bear with me for 2 seconds while I just transfer control to Alice.
Thank you, Alex. Hopefully you can all hear me. As Alex said, I'll be giving you a brief overview on other work routes, which will soon also be available to EU citizens, some of which can be seen on the next slide. The new system will make no substantial changes to the majority of these routes, but most will be aligned with the new skilled worker routes in terms of requirements, such as the financial requirements and the English language requirements. I'll be taking you through a few of those this morning. So I'll be taking you through the ICT visa, the business visitor visa, frontier workers, health and care, youth mobility, seasonal worker and students. So in terms of the ICT visa, my colleague Anne Harrod briefly mentioned it, but just as a reminder, for those who have an ICT license, this route allows businesses who operate abroad to transfer employees from a company based outside the UK to a UK affiliated company. The criteria is usually that the employee must have worked for the foreign affiliate for 12 months or more, unless their salary, and it's currently at 120,000, but it will be reduced to 73,900. And this will also allow them to stay up to 9 years in any 10-year period instead of the 5 in 6-year period under what is going to stay the current salary level of 41,500 or the relevant SOC code, whichever is higher. The role must still be qualified or experienced at RQF level 6, so that's degree level, so it will be higher than the skilled worker, which will be RQF level 3, as Anne Harrod mentioned earlier. And it must meet the minimum salary level, as I said, which is slightly higher than the existing skilled worker salary and will be much higher than the new skilled worker visa. The most helpful changes is that ICT employees who are switching to the skilled worker route won't be subject to the 12-month cooling off period when applying for entry, clearance or leave to remain. So moving on to the business visitor. To business visitors, this allows individuals to come into the UK for business purposes for a period of 6 months. They can work on specific internal projects with UK employees of the same corporate group, provided that no work is carried out directly with clients. This could include things like advising and consulting, providing training and sharing skills and knowledge. General business activities can also include attending meetings and conferences, providing talks, negotiating and signing deals, and carrying out site visits. They're not allowed to work for customers though, and their work must not amount to the applicant taking employment, doing any work which amounts to them filling a role, or providing short-term cover for a role within the UK organisation. And the non-UK company will still have to pay the individual, other than in very specific circumstances like the UK company providing travel expenses, things like this. That will also obviously all include EU citizens after the end of free movement, after the end of the year. And they will simply be able to apply for leave to enter as a visitor on arrival at the UK border, but it is understood that border control will have access to the history of the traveller, so they will be able to see whether the person has overstayed or come into the UK more times than they should, and can then obviously prevent them from returning to the UK. There are certain countries which do require a business visitor visa to be applied for ahead of time. A full list can be found on the government website, but it includes countries such as Afghanistan, Ukraine and India. Business visitors can enter the UK as many times as they like within that 6-month period. And if they do want to stay longer, they can apply for a long-term visit visa, which can last 2, 5 or 10 years, but with a maximum stay of 6 months on each visit. So turning to frontier workers. The frontier workers are individuals who work in one EU country but are resident in another. So under the current system in the UK, individuals are classed as frontier workers if they're an EEA national, they're not primarily resident in the UK, and they are classed as a worker or self-employed in the UK. This generally means that a frontier worker will usually return to their country of residence regularly, such as once a week, for example. So long as the individual satisfies the criteria before the 1st of January 2021, so as long as they're currently satisfying that criteria that I've just mentioned, and they continue to satisfy that criteria after the end of the year, then frontier workers can retain their status following the end of free movement. So as it currently stands, the same rules will apply as with the EU settlement scheme. So there will be a 6-month grace period, which I will come to in a moment, between the end of the year and the end of June 2021, which will allow the individuals to continue to rely on their passports and national ID cards to enter the UK. But from the 1st of July 2021, frontier workers will also need to hold a valid frontier worker permit to enter the UK as a frontier worker. The frontier worker scheme is yet to be launched, but we know that as long as the individual has not been in the UK for 180 days or more in any 12-month period, and provided they haven't returned to their country of origin at least once in the last 6 months or twice in the last 12 months, they will meet the definition of a frontier worker for the new permit. The application will be free, and if successful, the applicant will receive a 5-year permit. However, this permit cannot lead to settlement or indefinite leave to remain. So turning to the health and care visa. This visa, as you're probably aware, launched on the 4th of August 2020 as a subcategory of the existing Tier 2 general route. And it applies to individuals who have a job offer from the NHS and who are a sponsored doctor, nurse, health professional, adult social care professional. However, it currently doesn't apply to many roles within the social care sector, and there has been quite a lot of criticism around this. The Migration Advisory Committee's view, who, as Alex mentioned, advises the government on all things immigration, their view is that migration shouldn't be the solution in this sector. The issue stems primarily from salary levels being too low, and that should be addressed first before an immigration route is considered. Employers must confirm which SOC code when they are applying for this route, and expressly state which approved body will employ the worker. And they should let their employees know that they will need to ensure that they specify that they are, when they're applying for their visa, they'll need to specify that they are applying for the health and care subcategory, which will then allow them special treatment at the processing stage with things like shorter processing times. So it will only take 3 weeks, apparently. There will be a dedicated phone line, and them and their families will not need to pay the immigration health surcharge, which, as mentioned earlier, since the end of October is now £624 per year, or £470 per year for students and those on youth mobility. So moving on to the youth mobility scheme. This is an unsponsored route, which applies to those aged 18 to 30 who want to live and work in the UK for a period of up to 2 years. Those on the scheme can work in most jobs in the UK, but they can't extend their stay or get public funds. The route does rely on reciprocal arrangements with other countries. So currently there are 8 countries in the list, which are Australia, Canada, Japan, Monaco, New Zealand, Hong Kong, Republic of Korea, and Taiwan. It does not yet obviously apply to EU citizens, because EU citizens still have freedom of movement until the end of the year, but reciprocal arrangements are likely to be made with other EU countries. The new system will also allow those on the youth mobility scheme to switch into a skilled worker route, and the list will also be extended to include San Marino. Once free movement ends, this route could be helpful to, for example, students, EU students who want to go on the Erasmus scheme, for example. So another option is the seasonal worker route. This allows individuals to come to the UK for up to 6 months to do farm work. It's currently a pilot scheme, which will be fully reviewed at the end of the year, but the pilot has proved popular, with the number of applications being increased from 2,500 to 10,000 from February 2020. Obviously, again, it currently doesn't apply to EU citizens because they still have freedom of movement, but the National Farmers Union is concerned about this route because 99% of seasonal workers currently come from the EU. So it's likely that this is going to be needed moving forward. And the Migration Advisory Committee has advised that although they don't think sector-based visas are a good idea, they have made an exception for agriculture, and they have advised that an agricultural visa is made available, or agricultural route is made available. So finally, turning to the last one I'm going to be speaking about this morning, students and post-work study. So the new student visa has not substantially changed from the previous Tier 4 general student visa. Students can apply to study in the UK if they are 16 years or over. They've been offered a place on a course by a licensed student sponsor, and they have enough money to support themselves, and they satisfy the English language requirement. Finance requirements will be aligned with the other routes, and maintenance levels are being amended in line with the current home student maintenance loans. This route will apply to EU citizens who are coming to study in the UK from the 1st of January 2021, and they will be able to apply for this visa. There'll also be a new short-term study route which is being introduced for students who are wishing to come to the UK to study English language courses for between 6 to 11 months. Those who are coming for less than 6 months, or planning to come for less than 6 months, will be able to apply under the visitor visa route. But those on these short-term visas will not be able to switch into a student visa. The student visa means that the students will be able to stay for up to 5 years at degree level and up to 2 years below degree level. So I think the most significant change in this area is the new graduate route. This will see students benefit from the new graduate route from summer 2021, and will allow them to switch into the skilled worker route, which we spoke about earlier in the presentation, at any time in the 2 years after they graduate. So they will then be able to work in the UK unsponsored for up to 2 years after they graduate, or up to 3 years if they have a PhD. So I'll now be moving on to right to work checks. So as you're probably all already aware, all employers in the UK have a responsibility to prevent illegal working. You do this by conducting a right to work check. And if you're found to be employing someone illegally and you've not carried out that check correctly, you may face sanctions, including a civil penalty of up to £20,000 per illegal worker, and in the more serious cases, a criminal conviction carrying a prison sentence of up to 5 years and an unlimited fine. So it's quite serious. In order to conduct a right to work check properly, you need to obtain original documents, such as passport or biometric residence permit. Check that the documents are genuine, valid, and whether they have any work restrictions in the presence of the holder, and copy the document and record the date on which the check was made. There are currently temporary measures in place because I appreciate this is more difficult in light of the pandemic, and the government have recognised this as well. And these temporary measures can be found on the government website. All copies should be kept securely for the duration of the worker's employment and for 2 years afterwards. There's also the ability since January 2019 to undertake an online right to work check, which will also give a statutory excuse against civil liability. So after the end of the year, what happens to EU citizens? Well, you can still rely on their passports and ID cards up to the end of June 2021, provided that they arrived in the UK before 11 p.m. on the 31st of December 2020. So after June 2021, you will need to check whether your recruits have applied under the EU settlement scheme, and the deadline for applications is the 30th of June 2021. There's currently no suggestion that retrospective checks need to be done, so for those existing EU staff, but we do expect updated guidance to be published on this, so I think it's a case of watch this space at the moment. As Alex briefly mentioned, the settlement scheme will provide online proof only, with a hard copy proof only being available in the most exceptional circumstances, for example, vulnerable individuals. The only way for you to confirm the employee status under the scheme will be through the online system. So you will need to ask your EU citizens, your EU workers, for their date of birth and request that they provide you with a share code. This can be accessed through their online profile, or they can email it to you, provide it to you in person, and it will be valid for a period of 30 days. You must use the Home Office employer checking service. If you go through their profile, the employee's profile, that won't be a valid right to work check. And you will not be able to establish a statutory excuse against civil liability if you are found to have been employing an illegal worker. The Home Office does have an audit record for online checks conducted by employers using the service, so it is important that you ensure that you do these checks properly before employment begins, and also at the expiration of any time-limited leave. So when viewing the worker's right to work, you will need to check their photograph on the online system and also check, obviously, that they do have the right to work and there are no work restrictions which would prevent them from working. Once you've confirmed that this is the correct individual with the right to work, so for EU citizens after June 2021, this will be that they have settled status or pre-settled status. You should retain evidence in the form of their profile page. This page includes the individual's photo and the date on which the check was conducted. You'll have the option of printing the page or saving it as a PDF or HTML file. This should be stored in either hard or electronic copy for the duration of the individual's employment and for 2 years afterwards. So what happens in what is known as the grace period, so between the end of the year and the beginning of July 2021? Well, there is currently no Home Office guidance on how to distinguish EU citizens who arrived in the UK before or after 1st of January 2021. So whilst the current guidance does permit employers to hire EU citizens in this time period on the basis of their passport or ID card, we would advise that if there is a suspicion that the individual arrived after 11 p.m. on the 31st of December 2020, then the statutory excuse against civil liability for illegal working could then be challenged, given that there wouldn't be reasonable cause to believe the individual does have the right to work, does not have the right to work, in the UK. So unless they provided an evidence of another route, for example, if they did arrive in the UK after the end of free movement, so after the end of the year, they may then have a dependent visa, for example, which would then potentially give them the right to work. There's currently no easy answer to this, as the guidance specifically states that employers should not directly ask their EU workers whether they have applied under the scheme in this 6-month grace period, as it could be seen to be discriminatory. So we do recommend that you keep an eye on updated guidance, which will hopefully arrive before the end of the year. And if in doubt, for example, if their CV suggests that they have been working in an EU country after the end of 2020, then you could perhaps ask some subtle questions at the interview stage to ascertain when they arrived in the UK. A reasonable belief in the individual's right to work should then be documented, so that evidence could be provided to the Home Office if that's necessary. We also recommend that any offer should be made conditional upon all of your workers having the right to work in the UK. Employment contracts should be updated to include obligations on employees to inform you of their right to work, and if that right to work changes in any way, making it clear that failure to do this could result in disciplinary action being taken against them. And if you do suspect that you have an illegal worker, then action should be taken immediately on discovery. And just please note that suspending an illegal worker or a suspected illegal worker will not act as a defence to illegally employing them. So you may wish then to give your staff some training on right to work checks and the EU settlement scheme moving forward, so that you are able to support your existing EU workforce as well as others outside of the EEA, and to make sure that all of your staff know what to expect moving forward. So, turning to what's next. As we've already said, we hope to receive further updated guidance from the Home Office on various aspects of the new immigration system, including right to work checks and how EU citizens will fit into a number of the routes. According to the Home Office, it will continue to review the system and make changes where necessary. Therefore, it is likely that the new system won't be set in stone once implemented, and changes will continue to be made. For example, the Home Office has hinted that it is looking at a new unsponsored route, but it has said that it hasn't found the gaps yet to justify this type of route, but it does intend to continue to refine the new system and consider, as we said earlier on, consider additional tradable points, adding those to the list. As Alex said, a low-skilled route is not anticipated. We therefore encourage you to continue to watch this space, as I'm sure you've already been doing. But that said, many of the existing routes are not planned to have a major overhaul following the end of the year. So, what should you be doing now? Well, as we've already said, if you're not a sponsor already, but you do intend to recruit from both inside and outside the EU after the end of the year, then you may wish to consider applying for a sponsor license sooner rather than later. There are already a lot of businesses who are applying, and due to the ongoing effects of the pandemic, this is also slowing down application processing times as well. So get in there quick. If you're not sure whether you need a sponsor license currently, but it is worth assessing your existing workforce and reviewing business planning, future business planning moving forward to determine whether a license would benefit you in the future. If you're intending to recruit in the foreseeable future, you may wish to do it before the end of the year, particularly if you are reliant on EU citizens, because obviously EU citizens that are already in the country before the end of the year will then be able to apply for the settlement scheme, and you can then employ them without having to sponsor them, which would be much simpler and more cost effective. For your existing workforce, you should ensure that they know about the EU settlement scheme, for those who it's relevant for. You may wish to provide support and assistance in the form of newsletters, FAQs, and even designated sessions with your HR teams, if you've not done so already, in order to support your EU workers who have not already applied for the settlement scheme to do so before the end of June. Before the deadline. We would encourage you to ensure that your HR systems are up to date and functional, and consider providing your HR teams with training on the new system and a refresher on right to work checks and how they will work after the end of the year. The Home Office is more likely to be conducting checks and audits post 2020. So you should prepare yourself for this, including ensuring that your right to work checks are accurate and up to date, and that your policies and procedures are fit for purpose moving forward to enable you to continue to access the best talent without restriction. So I'll now pass you back to Angharad so that we can go through some of your questions. Sorry, bear with me a moment.
Thank you very much, Alice. I know that we have run over quite substantially, so I do apologise for that. Anyone who has asked questions, Alex has answered them for you in the questions section. If anyone does have any specific questions, please do get in touch with us, because we'd be more than happy to go through anything with you. If you've got any further queries, we'd be more than happy to take those. Thank you very much for joining the webinar, and we hope you have a great day. Thank you.